presiding. While court is in session, there will be no talking, sleeping, chewing gum, or reading any material. Thank you.
Thank you. This is case number 23-152244. This is Jabbar Grayson versus Brian Ambrose. The matter is before the court where there is an application for entry of a default judgment. The court has set the matter on in regard to that motion. Your appearance for any attorney who's appearing on either side, your appearance in first instance, please.
Thank you, Your Honor. Christopher Michaels, P83156, on behalf of Police Officer Brian Ambrose. And briefly, there was also the defendant's motion to dismiss in lieu of answer was filed. I don't know if today is the date and time for that as well.
I do have that matter that was filed with the court June the 30th and submitted to the court. So that is an issue that's before the court as well. All right, and do I have Jabbar Grayson on the Zoom? Say something if you hear it this time.
Yes, Your Honor.
The video begins by returning to Judge Coleman's courtroom to deal with a familiar sovereign citizen litigant. This individual has appeared before the courts multiple times and continues to rely on the same debunked legal theories. Previously, he threatened to sue a judge, and in this case, he has escalated matters by filing a civil lawsuit against the police officer who conducted a traffic stop. The narrator sets the stage by explaining that this case is not new behavior but part of a pattern. Rather than resolving his traffic matters through proper legal channels, the plaintiff attempts to weaponize civil court. This introduction makes it clear that the court will be addressing misuse of the legal system. It also signals that the outcome is likely to hinge on basic procedural law, not ideology.
Let me address the issue of the application for entry of default judgment in this matter. On what basis are you saying, Mr. Grayson, that you should be entitled to entry of default judgment in this matter, sir?
Well, Your Honor, we sent documents into you stating that I'm a national, a Morris American, and this highwayman has no jurisdiction over me. And we sent that information to you, and also sent, I believe I have a court, People versus Battle as a reference in the case.
I think that you're addressing something that don't have anything to do with my question. You submitted to the court a default request. Now, on the one hand, you're telling me that the court doesn't have jurisdiction. You telling me that the court doesn't have jurisdiction, and you're not submitting to the jurisdiction of the court. And why are you?
36th District Court of Michigan is formally called into session, with Judge Donald Coleman presiding. The courtroom rules are announced, reinforcing that this is a structured legal environment governed by procedure and decorum. These formalities are important because they demonstrate that the court operates under established authority. Unlike online forums or pseudo-legal arguments, courts function through order and process. The judge's presence immediately frames the seriousness of the proceeding. This moment contrasts sharply with the plaintiff's informal and ideological approach. It reminds viewers that beliefs do not override court rules.
A traffic court, that's not pertaining to you. What I decided to do was send you basically every information to communicate what I've been doing basically in 36th District Court, as well as this procedure.
I'm not a traffic court judge. I'm a civil judge. But I don't know what are you talking about?
Yes, sir. And I understand that.
All right, Mr. Michaels, address yourself, if you will, to both issues. One is the motion for entry of default, and then secondly, which I believe these issues might collide, the motion to dismiss in lieu of filing an answer, sir. Go right ahead, sir.
Thank you, Your Honor. I did receive a copy of the request for default this week, so I had no opportunity to respond. Obviously, the city the city law department who is representing this police officer filed its motion back in June, dismiss in lieu of an answer. So I don't believe there's any grounds whatsoever for a default judgment. The brief speaks pretty clearly on its face for why a dismissal is appropriate. There is no viable claim stated in plaintiff's original complaint, and since the defendant is was at the time and still is a police officer, he would be entitled to governmental immunity. It appears that it's some sort of dispute regarding traffic tickets or citations that were given for various matters that are currently pending in front of Judge Perkins right now. So it also appears to be some sort of collateral attack against those proceedings, which is under Michigan rules not permitted. So we would ask this court dismiss.
The judge identifies the case as Javer Grayson v. Brian Ambrose, involving an application for entry of default judgment. This is a civil lawsuit, not a traffic or criminal proceeding. The distinction matters because civil courts follow different procedural rules. The judge clarifies that the matter before the court concerns whether a default judgment is appropriate. This clarification narrows the scope of the hearing. It also signals that broader philosophical arguments will not be relevant. Courts focus on specific motions, not generalized grievances.
The defendant is in default in this matter. He's responded to the complaint. Default is when a party fails to act in the judicial proceeding, in a court proceeding, failed to act when they should have acted, and that therefore the court would be required to enter their default because of their failure. Things like failure to answer the complaint or failure to file a responsive pleading. The responsive pleading that was filed in this matter was filed in June. The case was filed, looks like June the 13th of 2023. The motion was filed June the 30th. So that's certainly within the time required by law to do a responsive pleading. So I don't see any basis for default. Default is what, like if the defendant did not answer or didn't file a response, then the plaintiff could move for entry of default. I don't see a basis for an entry of default in this matter. So the motion and application for entry of default is denied. There's nothing about this case that shows that the plaintiff is in default, or for that matter, that defendant is in default on anything. Neither party is in default. The case is right where it's supposed to be, and that is that there's been a complaint filed, and then there's been a responsive pleading. That responsive pleading is a motion to dismiss in lieu of filing an answer. If the plaintiff didn't file, if the defendant didn't file a motion, he would have had to file an answer to the complaint. So when there's a complaint, you've got to answer within a certain period of time by either filing a written answer or by filing a motion. Sometimes there's a motion for a more definite statement. Sometimes there's a motion to dismiss because the complaint is deficient or it has some legal flaw involved. This motion to dismiss in lieu of answer is filed alleging and arguing that summary disposition should be granted, or that a motion that the court should dismiss the case because there's no legal grounds or factual grounds for this case to stand on. What is this case about, Mr. Grayson, sir?
It's about a traffic, I guess is some type of traffic ticket. I started off Brian Ambrose's stopping me, and I believe I have the right to travel.
Attorney Christopher Michaels appears on behalf of Officer Brian Ambrose. He explains that a motion to dismiss in lieu of an answer was previously filed. This is a standard legal response to a complaint that is believed to be legally deficient. Filing such a motion pauses the requirement to file a formal answer. This immediately undermines the plaintiff's request for default judgment. The attorney's calm, procedural explanation highlights the contrast between trained legal advocacy and self-representation based on misinformation. It shows that the defense has complied with court rules.
The default judgment, what are you that you are saying, and what is pertaining to? We are still ready to proceed with the case.
What exactly is your cause of action? Because I don't think that you stated a cause of action that upon which the court could move forward with the complaint.
Well, actually, in traffic court 936 district, there's action being taken against me as we speak. This is a current case, and 36 district court has no jurisdiction over me. That's why I decided to bring it into civil court common law. And this is a 6-month case that's still going on. So,
all right, Mr. Michael, you get the last word on your motion.
Yes, very briefly, there was nothing filed by plaintiffs. And it does sound like he's disputing his traffic tickets in this court, which is a collateral attack, which the Michigan court rules and do not allow. So I think that's the best ground to dismiss this case, and we would ask this court.
I object, Your Honor. I'm disputing my birthright. I'm disputing.
Judge confirms that Javer Grayson is present and representing himself. Self-representation is allowed, but it carries serious risks when the litigant lacks legal knowledge. From the start, the plaintiff signals reliance on sovereign citizen ideology rather than established law. While confidence is not inherently a problem, misplaced confidence can be disastrous in court. Judges cannot act as legal advisors to self-represented parties. This moment foreshadows the difficulties the plaintiff will face. The legal system does not adjust standards based on personal beliefs.
You failed to state of action upon which the court can grant relief. This case and the complaint in this matter will be dismissed. It's dismissed without prejudice, meaning that if you can formulate a cause of action that is recognized in the Michigan law, then you can bring the matter if you can formulate case law or some type of law that supports your cause of action. It sounds like part of what is being said here is that as a sovereign person, you have the right to travel and et cetera, et cetera. And there is some basis for the same, but yet there is law that allows for law enforcement to stop individuals that are traveling upon the roadways. And so if that is what the cause of action is that they don't have the right to stop me, there is nothing in Michigan law that recognizes that. If, on the other hand, you find some basis to establish that the stop was in the form of some illegal activity, harassment, some advance against your person that is not permitted under law, or done under color of law, but not permitted under the Constitution, then you certainly have the right to bring an action here or in circuit court or in federal court. This case does not have any grounding to it. For that reason, the complaint is dismissed in this matter again, and the complaint is dismissed without prejudice. That would be a final order regarding this particular file.
Judge Coleman asks the plaintiff to explain the basis for requesting a default judgment. This is a critical procedural moment. A default judgment can only be granted when a defendant fails to respond as required by law. Instead of addressing procedural failure, the plaintiff launches into claims about being a Moorish American national. He asserts that the officer had no jurisdiction over him. These arguments are unrelated to default judgment standards. The plaintiff fails to connect his ideology to the actual legal requirement. This misstep significantly weakens his position.